Welcome, everyone. My name is Paulette Brown, and I'm pleased to be here with you with the UNR Committee of the American Bar Association. We have a very exciting program for you today. First, I want to say that this is a webinar, that it's being recorded, and hopefully everyone will enjoy the program. And I think that it will be available afterwards too on the ABA website. So I'd like to first get started with our introductions because we want to have as much time as possible for our program. So I'd like to introduce Laverne Lewis-Gaskins, who is our moderator. She's on screen. I think everyone can see her. She's an attorney arbitrator and former Georgia Special Assistant Attorney General, and she's also a member of our UN committee. And also we have Ligia, I should have pronounced this, Saquiche. Help me out. Is that good?
Yeah, Ligia Saquiche.
Okay, great. Thank you. She's a university professor, and she's a women's rights advocate and former prosecutor, advisor, and criminal investigation. Welcome. And then we have Zamira Zabarova, international senior legal advisor for the ABA Center on Human Rights. And we have Melnia Cordes, who's to my right, who's a private immigration practitioner here in New York. And she's practiced in Trinidad, Guyana, and the US, focusing on immigrants from the Caribbean. And then we have Alicia Lamtiaco, attorney, former US attorney, for Guam, and is also on the UN committee, and she's a candidate for Congress, if I might say that. So, first, we're fortunate enough to have the ABA president has many duties, and she's traveling all over, but she took the time to record a message for our program. So if we can tee up and listen to the president.
Good afternoon. I'm Michelle Banky, President of the American Bar Association. It's an honor to join the UN Representatives and Observers Committee, along with the UN Commission on the Status of Women, for this program, as we look at the critical access to justice issues for Indigenous and migrant women around the world. Thank you to the UN Representatives and Observers, including past ABA President Paulette Brown, Isabella Bunn, Randy Hansen, and the entire team. Thanks also to the ABA Center for Global Programs and the Center for Human Rights, including the volunteer leaders and staff leads, Scott Carlson and Daniel Anderson, and their teams for their commitment to this important work. I want to give a special thanks to Eileen Gotts and Wachtel Lipton for hosting us today. To our esteemed panelists, your expertise and knowledge on these issues help spotlight access disparities that can often be a matter of life or death. Thank you for being on this program and the work you do every day. According to the Department of Justice website, Indigenous and migrant women face severe barriers to justice. In the U.S., 84% of Indigenous women experience violence, with 38% lacking access to legal, medical, or other necessary services. For migrants, limited language access, fear of deportation, and legal barriers such as limited visa awareness can hinder access to justice. Migrant women also face high risks of workplace exploitation, such as unpaid wages and abuse. These women often avoid reporting these events due to fear of retaliation. 69% of judges report a large number of limited English proficient residents in their jurisdiction, yet access to interpreters or legal aid remains a top barrier. The lack of services in rural or Indigenous communities is a real issue affecting people's lives, not to mention the distrust of authority figures that some women often have. Today, we'll discuss how unequal access limits women's ability to exercise their rights, participate fully in the economy, and protect their families. We'll also discuss solutions for these issues. The American Bar Association remains committed to equal access to justice for all, domestically and internationally. Thank you for being here. Your participation and support of this important programming is so important.
With that, so that we can keep moving, I'm going to turn it over to our wonderful moderator, Laverne Lewis Gaskins, to kick us off.
All right. Well, good afternoon, everyone. It's certainly a pleasure to be a part of this panel, and I look forward to this conversation and your remarks. We're going to start this webinar with an overview of the context for this discussion regarding the similarities for women seeking access to justice in both communities. And Zamira, if you could start us off and give us just a brief overview, and then we'll launch into our conversation.
Thank you, Laverne. As Paulette mentioned, my name is Zamira Jabarova, and I'm with the Center for Human Rights of the American Bar Association. When thinking about Indigenous women and women migrant workers, one can sort of just even intuitively think about the various commonalities and barriers of accessing justice that they have, right? But at the same time, the sources of those barriers can be vastly different. What is common from our work at the center, what we have seen is that the justice systems that are set up in various countries, and my experience comes from the Center for Human Rights, which does international work everywhere, not so much in the United States, but in every other place. When justice systems are set up, they very rarely include women migrant workers or any migrant workers or Indigenous people in the design process of these justice systems. So almost by design, they're set up in exclusion of the concerns of these communities, right? So kind of that is in the context of today's world where there's racialized capitalism, as well as gendered and class power imbalances, that kind of lack of participation in the very design of the justice systems has direct implications for how then the relationship between these justice and judicial systems and these communities play out. So that then results in a kind of the way that these communities relate. There isn't much of a legitimacy or sort of trust in these systems, which then leads to lack of even the trust to go to these systems, to use them, and it kind of goes into this reinforcing cycle. At the same time, there are very practical ways in which these systems can be responsive to these communities. And some of the very specific and sort of ones that governments can remedy quite easily are things like language, right? Sort of ability to access judicial or justice systems in the languages of the Indigenous peoples or the migrant workers who tend to come from specific countries, and therefore you can determine the languages that should be serviced. Secondly, the fee systems. Often judicial systems require posting bonds to access them, etc. So ability to access, so the fee systems are also can be easily sort of addressed. The other kind of barriers that are ingrained in the very claims that they bring, where, for example, accessing legal aid or judicial system itself is dependent on citizenship status, or if you're bringing it as a worker in your recognition as a worker. So those kind of things that are easily identifiable, and it's only about sort of political will and allocation of resources and prioritizations to address them. So the reason I'm talking about these elements is that in setting up the context, I want to sort of emphasize that even though the sort of barriers and needs of various communities, not within indigenous groups, right? There's different kinds of indigenous groups who have different needs, priorities, issues, similarly for migrant women workers. So you can't say they're all the same, but there are at the same time very practical solutions to facilitate greater access to justice. So in that, but the panelists today have very specific experiences in working with various communities, and we'll be able to hear about how, and maybe at the end of it, also draw additional parallels in how the relationship between justice system, accessing justice for Indigenous women and women migrant workers play out. Thank you.
Well, thank you, Samira, for framing our conversation. And we will just delve into the particulars with Melania. I want to start our conversation with you. In your specific experience, what are some of the practical struggles that migrant women face in accessing justice in the United States, either in U.S. immigration courts or in the broader space of the judicial system?
Thank you, Laverne. Migrant women fall into several categories, but in terms of responding, I will speak to those who are out of status or those who may have the lawful permanent residence, and this doesn't pertain to US citizens. So primarily, the most palpable fare currently in the US for most migrant women and people of Indigenous background is the fear of deportation. We are all quite aware of the current government policies on immigration. So most persons who are here in the US who are out of status, currently they live in fear as to whether or not tomorrow or the next day they may be detained, whether going or coming from their place of worship or visiting family or friends. So deportation is right now, in my opinion, the most palpable fear that most migrant women face here in the US. Second, in addition to that fear is the lack of knowledge in terms of where to go for resources with respect to whether it's the law or legal policy or just gathering general information for healthcare or general assistance if they need financial aid. So where do you go to if you are new to the US and you don't have a family here or a support base? They live in constant concern as to whether or not if they go to a particular police station or if they make a report as to domestic violence, whether these complaints may trigger some sort of retaliatory response or whether they might end up in ICE hold or some form of immigration consequence. So there is that fear of where do you go for a trusted resource? In addition to that, as Samira mentioned, we have the language barrier that some migrants women may encounter. Some women from the Caribbean, they're fortunate enough to have English as their first language, but there are other migrant women that come here, especially in New York, that have English as a second language. And so they have to take classes to basically communicate. While there may be pockets of communities that you can exist in within your culture that may assist you in terms of communicating with respect to that language, when it comes to obtaining legal resources, especially with respect to immigration, it's a struggle to find those resources within the community. In addition to that, there is the issue of financial impecuniosity. Legal services is not cheap. Most lawyers, if you go to a law office, if you have an immigration related issue, you have to pay a consultation fee. And then there's a fee for the work itself that has to be done. So a lot of migrant women are reluctant to even approach a law office or an attorney because they are concerned as to whether or not they can afford the services. So these are some practical concerns and struggles that migrant women face here in the US, whether it's accessing resources from a legal perspective or just general resource to exist here in the community.
Thank you, Melnia. Alicia, I want to move to you. Similarly, what are your thoughts about some of the barriers Indigenous women face in their access to justice in the Pacific? What has been your experience? And please feel free to explain any geographic distinctions or considerations related to that area.
Thank you, Laverne. By way of background, and because there may be those that are participating in this webinar that are less familiar with the Pacific region, I'd like to give an overview. So we have Pacific Island nations and territories serve as stewards of nearly 1/5 or 20% of the Earth's surface and possess profound cultural and spiritual connections to our expansive ocean and land, which we honor as a collective legacy. The Pacific region itself is immense. It encompasses thousands of islands and vast stretches of ocean. It includes independent states as well as territories that are affiliated with countries such as Australia, New Zealand or Aotearoa, France, and the United States. Geographically, the Pacific is divided into 3 subregions. We have Melanesia, Micronesia, and Polynesia. And in terms of Melanesia, when we describe societies in each of these subregions, societies in Melanesia are typically organized around clans and tribes, with traditional customs and leadership playing central roles. Micronesia, though more linguistically similar, is characterized by extended family networks, matrilineal inheritance in some islands, and a rich legacy of seafaring and navigation. And then we have Polynesia, which is linked by the Polynesian Triangle of Hawaii, New Zealand, and Rapa Nui. And in Polynesia, societies share cultural traditions and languages, and it's known for its chiefly systems, oral histories, and practices such as navigation and dance. You may have also heard the concept, the Blue Pacific Continent. That underscores the unity and the shared stewardship of the region. It spans millions of square kilometers, far exceeding the size of any US state and even larger than the continental United States. And the Pacific Ocean itself covers about 63 million square miles, representing 1/3 of the Earth's surface and more than half of its water surface. And I give that context because in the response to the question and given the vastness, right, of our Pacific region, my responses are going to be, again, an overview of the barriers. And so Indigenous peoples in the Pacific region do face unique challenges that are deeply rooted in our colonial history, in geographic location, and certainly modern economic pressures. The region is home to, again, a diverse range of Indigenous communities, and each of these communities do have distinct cultural practices and governance systems. But many of our communities do share common issues, such as struggles over land rights, the effects of climate change, cultural preservation, and access to international human rights protections. When we talk about key challenges and barriers in the Pacific region, Indigenous women, who make up about 2.5% of the global population, encounter barriers such as language, lack of or limited awareness and accessibility to resources, including geographic isolation and geographic remoteness, discrimination, and a lack of culturally relevant legal services. There is also low awareness and a lack of political will among authorities, organizations, and donors that can cause major barriers. Initiatives must target not only, of course, Indigenous women, but they must also target the external actors. Another barrier or challenge is that formal justice systems are often inaccessible or insensitive to Indigenous needs, while Indigenous justice systems are frequently either unrecognized, restricted, and in some cases even criminalized, which of course then undermines their effectiveness and their legitimacy. There are discriminatory practices, colonial legacies, and systemic bias that contribute to high levels of violence, impunity, and marginalization, especially for women with disabilities and those that do live in conflict zones. Another barrier or challenge is we have limited, inconsistent, and under-resourced support services that pose major barriers to effectively address violence against women. There's also insufficient data on Indigenous women and limited documentation of rights violations. All of these, again, hampering ways in which we can develop evidence-based advocacy and reporting. And then climate-induced injustice, rising sea levels, and environmental degradation, all of these threaten ancestral lands and traditional knowledge, fracturing the cultural foundations that support Indigenous women's customary justice systems. And as we talk about these key challenges and barriers, we do know, again, we're talking in the context of international standards. So we have, for example, CEDAW General Recommendation number 39 and the United Nations Declaration on the Rights of Indigenous Peoples, which affirm Indigenous peoples' rights to self-determination and our own legal systems. Some of the ways in which these challenges and barriers have been discussed and recommendations that have come forward include state actors ensuring Indigenous women have full and discrimination-free access to both Indigenous and non-Indigenous justice systems, involving them in decision-making, and offer culturally competent legal services. There are also legal reforms that must be constitutionally recognizing Indigenous justice systems and respecting these decisions and ensuring their alignment, again, with international human rights standards. Efforts should also be focused on dismantling discriminatory attitudes, improving legal aid, ensuring fair trials, and upholding equality before the law and providing protection from violence. There should also be the support involving the collection, documentation, and the use of disaggregated data and culturally grounded indicators that are co-developed with Indigenous peoples and Indigenous women that also include rights violations of Indigenous women, as well as what we consider good practices. And then again, also enhancing the coordination between the justice systems and increasing the participation of Indigenous women in leadership roles. All of these are essential for what would be considered meaningful progress in terms of Indigenous women's access to justice in the Pacific. Thank you.
Thank you so much, Alicia. There are significant barriers that certainly women need to overcome and can overcome in that region. Alicia, please share your thoughts about the barriers to access to justice for Indigenous women in Guatemala. And please identify any issues related to geography that may influence those barriers.
Thank you, Laverne. Well, to begin talking about Guatemala, I'd like to provide some background information. Guatemala is known for its rich cultural diversity, following a 36-year internal war and a series of genocidal acts against the Mayan population. Peace accords were signed, officially recognizing that the country is formed by 4 groups: Ladino, Xinca, Garifuna, and Indigenous. However, this description does not fully align with the self-identification of many communities. For example, there was an effort of homogenization that has been with Indigenous people. There are 22 Mayan groups in the country, each one with its own language, territory, and customs. I highlight this point because it illustrates how official history and the state often fail to recognize the identity of the most of its population. If we analyze the period since the signing of the peace accords in 1996, there was already a commitment to strengthen the justice system, and we can say in general terms that some progress was being made in these years. But with the presence of the International Commission Against Impunity in Guatemala, called CICIG, a United Nations body that investigates parallel power structures and that work closely with the Public Prosecutor's Office, it was possible to identify how economic, political, and even criminal power groups control the government. However, after the CICIG's expulsion in 2019, many of the actors identified in these investigations recaptured the control of the justice and political systems. This setback here has been evident, generating moments of political and democratic tension for the country, which significantly impacts in the increases of the historical gap in access to justice. Indigenous people represent around the 44% of people in Guatemala, of the population here, and are still systematically the most affected by inequity and discrimination. From my experience, I will say the main barriers to access to justice for Indigenous women are the ongoing challenges of racism and discrimination in our society, as well as among the law enforcement professional and within the justice system. The insufficient information regarding the rights of Indigenous women and the process of the official justice system. The language barrier is a notable issue, particularly with the absence of interpreters in official institutions. But also the financial implication of accessing to justice must be considered. For us, it's supposed that justice is free, but I'm gonna tell an example. We have in a department called Sorola that is known for their famous Atitlan Lake, is the biggest lake in the country. If a woman is a victim of violence and doesn't live in the department's main town, she will need to pay for a boat round trip to cross the lake. Then she has to take a ground transportation to reach the municipal center where all these institutions are located. Then attend the proceeding, which maybe will take her about the day. This means she will have to buy food, and in addition, she will probably be accompanied by her kids, as she's traditional, the primary caregiver. So for many women, Indigenous women, especially living in rural areas, this seeking for justice involves also a considerable financial burden. So leading them often to choose to remain silent. Thank you.
Thank you so much, Licia, for your very informative remarks. And I'm going to move now to Zamara. Based on your experiences in different countries, can you share some of the access to justice issues that migrant women face?
Sure, thank you. I'll talk about our ongoing program that we have in the Gulf states. The program is a regional program that focuses on the rights of migrant women workers from African countries to the Gulf states. Although the women migrant workers are in various sectors, predominantly they are domestic workers. So domestic work is predominantly carried out by women, and in this sort of relationship, in the way the migration flows, there's a number of sort of thresholds where the rights of these women are repeatedly violated, and this could be during the recruitment process, during the actual travel, employment, any interactions with sort of registration, whether that's government services or sort of third-party registration processes. And all of these points where the rights are violated, these are sort of places where if these women have access to justice, they would try to bring to access remedies, right? However, one of the main, and this wouldn't be news to anybody here, but sort of the kafala system, which is the dependency of women on the employer for their residency and work permit, that system as a whole not only keeps them so dependent on the employer, but also impacts the ability to access justice because of how vulnerable they are to the employer. So most of the time, employer, once they're in that employment relationship, the employer might be the sort of the source of abuse, right? So where you're dependent on somebody and they're the source of abuse, then your ability to bring a case or any kind of complaint against them is, of course, almost impossible, even if you were otherwise sort of able to access justice. So that's that particular sort of dependency relationship is a specific one that is also present in other parts of the world, but in different countries, there have been attempts to move away from it. For example, we have worked in Serbia, where as a result of advocacy of many of our partner organizations and civil society groups, the new law, which was not new anymore, it's been about 2 years ago, kind of divorces that dependency between work permit and residency. So if you lose your job, you don't automatically also lose your residency, but you can then have some grace period to be able to get a new job. So diminishing that kind of dependency also then impacts ability of women to bring their cases to the authorities or even nonprofit organizations, because they are able to maintain their status. So that's just like a highlight. But the second aspect I want to talk about, in addition to what my colleagues here have talked about, is justice is often weaponized. The judicial justice system is weaponized against these communities, right? So the very attempt to use the judicial system then can sort of be turned around against them. So how does that play out? In the case of migrant women, this can be often cases, especially when it comes to the issues of domestic workers, if there is an allegation of the sexual abuse or domestic or gender-based violence, and that complaint is brought, they often countersued for defamation, right? Defamation-based countersuits are very common all over the world, including here in the United States. And in many countries, sort of anti-SLAPP provisions are extended to these complaints. Sort of, I think one of the leading jurisdictions is Australia in that case, where once there is that power imbalance, the burden of proving also shifts, where then now the employer has to show that the allegation did not happen, as opposed to the migrant worker having to show, well, this is not just specific to women migrant workers, it's women who are alleging sexual violence or gender-based violence. So weaponization against migrant women workers can also happen in the case of let's say if they're working in a factory, for example, and they try to use the complaint mechanism, whether that's at the employer level or extended by the government services to like if there is issue of wage theft or any other labor rights violation, then just the virtue of raising that complaint can lead to their blacklisting. So we have documented this, for example, in Ecuador, in the agricultural sector, when migrant workers, including women migrant workers, in the case of women migrant workers, bringing cases of gender-based gap in pay. So where there is a widespread practice where women are retained on part-time contracts, but they work full-time. So when they brought these complaints, then they were marked, then they would be in the system for bringing that complaint. And we documented that the human resources of these companies had the practice of going and checking in the judicial database to see, before hiring anybody, had these people, workers brought any complaints before, and kind of this giving rise to this informal blacklisting mechanism. So, you know, no matter where you work, even you actually worked up the courage and overcame all of those barriers that my colleagues talked about here in trying to access justice, to bring some accountability, then that very justice system can be weaponized against you. And similarly for Indigenous women, of course, in the context of land rights that Alicia mentioned, and for example, mining companies, the sort of retaliatory SLAP cases, strategic litigation against public participation, whether that's based on defamation, trespass, for protesting, these are often also brought against Indigenous populations. But the way it plays out also differently for women is that then that is used as a sort of a component of gender-based smear campaigns against women for being outspoken and proactive. So that's, those are my comments.
Thank you so much, Samira, for those remarks. I mean, we have to have these webinars, these type of webinars to raise awareness and to keep people informed about the conditions that women oftentimes face. All right, we will continue with our wonderful panel discussion. Melia, let's ask you a few questions, or a question. Are you aware of any efforts to improve migrant women's access to justice in the United States or elsewhere that have been successful?
Well, success is somewhat subjective. It really does depend on what side you're looking at issue of access to justice from. With respect to providing a response, I'm going to look at it from the US perspective, and just generally in terms of what options are available to migrant women in terms of being able to seek relief if they have any judicial issues or any legal issues. So generally speaking, I would say with the advent of legal aid throughout the US, especially here in New York, that is a primary opportunity and an example of success for women with respect to access to justice. I remember when I first came to the US in 2003, there was a Brooklyn Legal Aid that I knew about that provided legal service to migrant women here in the US. But now if you go online and you just type in legal aid service, there's a proliferation of organizations that provide free legal services, reduced cost legal services. And what is important to note is that it's not just limited to governmental agencies. It's also been extended to non-governmental agencies such as community groups, religious organizations, and even hospitals. There are some hospitals here in New York that have access to lawyers that would assist persons in the hospital, whether it's a domestic violence situation or some other issue where they would need legal assistance. They would provide access to an attorney or to a legal service that can assist them with whatever issue they may have. And with respect to the matter that Zamira raised in terms of retaliatory litigation, I just want to highlight that there are so many organizations in New York that would assist women and migrants, persons generally, whether we're male or female, in terms of helping them, especially from an immigration standpoint. If someone is here and they have a work authorization or they have an asylum case that's pending, and for some reason or the other, someone makes a report and the employer decides that they're going to terminate their employment, there are agencies here that take swift action to ensure that their legal status is continued and that whatever legal paper has to be filed is filed to ensure that their rights are protected. So from that standpoint, I can say with much confidence that when it comes to getting access to justice in New York, there's a proliferation of organizations, and you can see it from a governmental standpoint. A lot of the senators and political representatives have legal clinics that they do on a regular basis, covering various topics, whether it's immigration or landlord and tenant matters, real estate, domestic violence. They provide that legal service, or the access, I should say, to lawyers and the legal organizations that will be able to help those persons that are in need. Outside of the political and the governmental arms, we also have the Office of the District Attorney that has a special immigrant section that assists persons if you're a special victim or if you're part of some issue with respect to a gang, or if you have a special immigrant issue. The Brooklyn District Attorney has an immigration arm that would basically assist persons, one, to get their green card status based on whatever that matter, if it arose from a criminal incident. Additionally, we have the various bar associations that would provide access to attorneys who would set up consultations for persons for free. The initial consultation is free, but if you need additional service, you may be required to make a small pecuniary payment to that attorney. But in terms of the successes, I do believe that the proliferation of legal services, free legal service or reduced legal service here in New York is one of the highlights in terms of success for access to justice for women. Secondly, I believe that with respect to the opportunities where persons can represent themselves, which is what we call pro se representation in the court, that is also another success measure or a success tool that I would say would allow women to have access to justice. And even in instances where they may have a language barrier, most of the courts and other organizations provide translation services for pro se litigants, special designated offices within the courts throughout the U.S., New York jurisdiction, I should say. So the increase of free legal services and the proliferation of the pro se opportunities, together with the fact that most persons may have access to internet and all of these services are listed online. They include email contact, phone contacts, and various organizations where you can get it for free. And with the advent of AI now, you can literally just type in, tell me where I can get free legal service for, and you put in whatever your need is, and you can put in your zip code, and the AI outcome, if you're using Gemini AI, will literally tell you what's the closest thing organization to you that you can go and seek assistance. So for me, I do believe that in terms of the successes, those are some of the topical ones that I would say are prevalent now in our community that women can access justice.
Thank you so much for that information and those resources that are extremely valuable in accessing justice. Alicia, I want to pivot to you. What are some of the advancements or accomplishments Indigenous women have made in access to justice in the Pacific, especially in conjunction with governmental or legal reform?
Thank you again, Laverne. Indigenous women in the Pacific continue to transform and champion access to justice. Indigenous women in the Pacific, for example, are at the forefront of advancing legal pluralism or legal diversity, meaning advocating for the formal recognition and the integration of customary and state law systems. Indigenous women in the Pacific and their efforts have resulted in significant constitutional reforms, empowering Indigenous authorities and securing the right to apply customary law within legal frameworks. By promoting this legal pluralism or legal diversity, they are ensuring that justice mechanisms are more accessible and that they are culturally relevant to the communities in which they live. Indigenous women have also been shown that they are advancing restorative justice practices that are rooted in Pacific traditions. And so there we are prioritizing traditional community healing and dignity over punitive approaches. There have also been and continue to be concerted efforts to address violence among Indigenous peoples and against Indigenous women that reinforce what we call a culturally integrated approach to the community's strategy. And although we recognize that there is value of formal systems of Western care and services and that these are acknowledged, the infrastructure, this Western infrastructure by itself is not enough to address the historical trauma of colonization. So we have community resources that then go beyond the traditional systems of care that include not only those that are basic to survival as food and water, and then the traditional ways or systems in which we cultivate and access those, but we look at the natural elements, the landmarks, the patterns, the neighbors, and the communal events that create a sense of belonging that victims and others then feel and describe as being home. Indigenous peoples' beliefs and attitudes about behavioral and mental health are and should be integrated also into the development of programs because Indigenous peoples and Indigenous women find that they are inseparable when we talk about issues of environmental degradation, loss of land, and political disenfranchisement. We have also seen in the context of Indigenous women and accomplishments in the realm of access to justice in the Pacific that there have been some legislative and policy reforms that relate to violence against women. For example, the repeal of certain discriminatory laws. There's the expansion of some legal definitions, such as the inclusion of marital rape in the definition of rape. There are Pacific countries that have also increased the levels of severity when it comes to domestic violence, crimes, or charges, and have introduced restraining orders and rehabilitation and treatment measures for the accused or perpetrators of violence. We have also seen that Indigenous women have been a driving force in terms of governmental and legal reforms when we speak about addressing gender-based violence by leveraging the influential platforms. So, for example, this may include the Pacific Islands Forum, which is an intergovernmental entity, and the Pacific Islands Forum demanding sweeping reforms in how state legal systems confront violence against women and girls. In the area of land and resource rights, there are women-led movements that are compelling governments to draw clear boundaries between company and community land, which then empowers the Indigenous communities with legal tools to fight land grabbing and protecting their heritage. We have seen Indigenous women in the Pacific build strong regional human rights networks. These networks then amplify their voices. They influence government policies. The Pacific Indigenous Women's Network and the Pacific Human Rights Defenders Network, both of which were established in Guam and in Fiji in 2019 respectively, are examples. They are led by women. They advocate for justice and human rights protections of Indigenous women. We have seen Indigenous women be very instrumental in engaging with the United Nations, particularly in advancing the UN Declaration of the Rights of Indigenous Peoples, and again, ensuring protections against violence and discrimination. So the coalition building, the advocacy programs, all of these are again positive efforts, again, in Indigenous women accessing justice. They have been expanded to involve traditional leaderships, churches, faith-based organizations, male advocates, the media, and the private sector. We have seen that the delivery of crisis center services, counseling, medical care for women has also been improved because we've seen the establishment of referral services and structured training for police or law enforcement personnel, and the equipping of police forces, for example, or police stations with female officers who respond specifically to domestic violence incidents. And again, these sort of delivery of services, the training that we speak to, have come about from Indigenous women advocating for, again, more having a greater and stronger response so that they can move forward in terms of the access to justice. We have Pacific Indigenous women who are champions and at the forefront of climate justice. And so using international legal platforms to seek accountability when we talk about environmental harm and protecting our communities and cultures, given the severe impacts of climate change on Indigenous peoples and climate crisis that we see in the Pacific region. So, thank you.
Thank you, Alicia. Alicia, from the perspective of Guatemala, what are some of the achievements that Indigenous women have made that could serve as examples in other countries?
Okay. Well, despite the calls from Indigenous women for respect of their rights, the state has made some efforts to create specialized institutions. However, these initiatives have had little impact because they are fragmented, not well discussed with Indigenous communities, have no political influence, or are insufficiently financed. However, Indigenous women have shown us through relevant cases how they can change adverse situations, and I would like to share two examples. The first one is the recognition of discrimination as a criminal act, followed by the first ruling. In 2002, the anthropologist Irma Alicia Velázquez Nimatug was denied the entry to a bar due to her clothing. She was wearing a traditional Mayan dress. Irma Alicia decided to file a complaint, but at that time, discrimination was not yet recognized as a crime. The case received media coverage, and Indigenous organizations, institutions, and activists expressed her support. As a result of this bad situation, the criminal law was reformed, and discrimination was regulated as a crime. 1 year later, in 2003, Rigoberta Menchú, the Nobel Prize, was inside the courtroom in the Constitutional Court. She was waiting in the court's decision regarding a legal action that sought to prevent the presidential run of Efraín Ríos Montt, who was accused later for genocide. And when she was leaving, several supporters of Ríos Montt's party shouted discriminatory slogans to her. After this attack, Rigoberta Menchú filed the first complaint of discrimination, and 5 people were sentenced. This trial represents a significant achievement, demonstrating that actions that had been widely accepted could potentially have consequences. However, even though this was an example, as a country, a little more than 20 years later, reports of discrimination are very low. And this is not because the legislation has been insensitive for this behavior. On the contrary, it shows how racism persist and limit access to justice and guarantee impunity. The second case is about Sepur Sarko ruling of the 2016, which dealt with acts of racism and sexual violence against Indigenous women during the internal war committed by the military, where rape was used as a mechanism of terror due to the state policy of considering Indigenous communities as the internal enemy. This case represents an example of joint work between women's organizations, survivors, and some officials of the prosecutor office. The investigation was carried out by a multidisciplinary team that respects the Mayan worldview and provides psychosocial support to help survivors overcome their trauma. This allowed the experience of these women survivors to be documented and strategic human rights litigations to be used, resulting in the women breaking their silence after so many years and opening the door to justice. In 2022, there was another conviction against former members of civil self-defense patrols serving the Guatemalan army, and this case is known as Mujeres Achí. So I think that we have this case like Sepur Sarko and Mujeres Achí women as an example of justice for our country, for our history, but also for the history of the world.
Thank you, Licia. Zamira, could you please share your thoughts on some successful programs that governmental or international bodies have implemented that incorporate migrant women's participation, particular justice concerns?
Sure. I'll pivot the conversation a little bit at this point, because to this point we have been talking about the government as a duty bearer and sort of the role that the government must and should and obligated to play in sort of facilitating access to justice to these communities. But the other very prominent actor is the corporations, right? Sort of particularly when it comes to labor rights abuses. We live in a world where, as opposed to seeing labor rights as the guaranteed rights that should be complied with, labor rights are seen more as labor costs. And costs are always, corporations and businesses always strive to minimize those costs. Minimizing labor costs means often violation of the guaranteed labor rights. I want to put that as a sort of a context, and some of the kind of I wouldn't necessarily even call them successful, as you noted that it's kind of depends on the eye of the beholder, but maybe some sort of strides or improvements have been in seeing the rights of migrant workers as the rights that they have, but also seeing that the contributions, the sort of economic contributions that migrant workers bring to the table, migrant women workers bring to the table, and civil society groups and unions kind of using that to make an argument that everyone benefits, corporations and governments benefit from the work of these women, and therefore they need to give it back in the form of services and protections. So we know, for example, the Philippines has one of the most advanced frameworks for regulating migrant labor, and that also has come with protective services that the government of Philippines has extended. So in our work, for example, in like Gulf countries, we see that Filipino workers are treated very different from workers from other countries because the government of the Philippines has sort of these bilateral agreements with the countries, the worker receiving countries, where these protections are built in. In addition, I mean, this is all relative, right? Like, I'm not trying to say the Philippines is like sort of has all of the things figured out, but it's all in comparison. The embassies and consular services also extend services, sort of welfare services for the citizens of the Philippines who are migrant workers in these countries in accessing justice and remedies. And that kind of also changes the treatment of these workers. So looking at this experience, we have been working with civil society groups and unions in Uganda, for example, to do an overview and mapping of the kind of benefits and sort of economic benefits that migrant workers bring to the government, to businesses, to recruitment companies, and using that kind of calculation to make an argument that, well, you have to put those resources back towards providing services and protection for these workers. And that's sort of the advocacy plan for increased services at the embassies, better regulation and of the recruitment companies. And so that kind of advocacy group work is underway based on the experience of the Philippines. So that's one example I want to share. But going back to this idea of the companies being also having to be directly obligated or responsible for the abuses of workers' rights, including migrant women worker rights, where we have seen, and I'll talk a little bit about that in the next sort of round, but we've seen there have been improvements in legislation and human rights due diligence legislation starting out in Europe, but now is also happening in some of the Asian countries, as well as the forced labor regulations here in the US, as well as in the EU, where corporations should be directly responsible for abuses of workers, including migrant women workers. And that kind of sort of using international standards that are at play for that responsibility has, well, we're hopeful. I mean, there's already changes, but hopefully there'll be more changes in the corporate behavior when it comes to treating labor rights as labor cost, right? So that's the second sort of hopeful development that is happening, even though it's not at the level that we were hopeful. They have been pared down quite significantly, but nonetheless, it should make an impact on corporate behavior. And then thirdly, in terms of some of the positive developments, based on the Australian example and the Serbian example I noted, but kind of, and studies that the ILO and IOM have done, one of the most important factors in impacting women's migrant rights, ability to access justice, is putting a firewall between the immigration status and the ability to assert their rights. So like in the US, there is that visa as well as in Australia, where if someone is a victim of a crime or trying to assert their rights, but their sort of work permit has expired, there is this extended or a particular specific status as a victim of a crime, or in more expanded versions, just as someone who is trying to assert their right. So the ability to remain in country for additional 6 to 12 months, or hopefully more, if needed, that facilitates the ability to assert and pursue their rights that could be related to wage theft, gender-based violence, any other violations. In addition, sort of again, often what I noted earlier in the first time, where women, specific sectors of work where migrant workers and specifically migrant women workers are more represented, those sectors often lack protections. So for example, domestic work is one that I have already talked about, but the platform-based work, right? Delivery workers might be mostly men, but there's also care, sort of cleaning services that is also platform-based. All that work is not recognized as work. They're not workers with extended benefits or even ability to use sort of specialized tribunals that might, or courts that might be for workers. We are seeing some strides in sort of movements in changing that, in actually recognizing. So for example, the Convention on Domestic Workers, recognizing domestic work as just any other work. And now ILO, there's movements in the ILO to recognize platform-based work just like any other work. Not so much to share like very successful examples, but I'm here to share some of the hopeful beginnings that we're seeing, both in normative developments, but as well as some of the behavior of employers that we're seeing. And maybe next year, there'll be some successes to report on that.
Well, we can only remain hopeful. Melania, are you aware of any successful efforts by nonprofit organizations or legal aid groups that have addressed migrant women's access to justice?
I will start by giving you a little background as to where I started and where I first was exposed to legal aid. So I went to law school in Trinidad, and at Woodin Law School, there's actually a clinic there that introduced law students to legal representation. And part of the clinic service is to assist persons of low income or low means to access justice. And so as a student there for 2 years, we participated in the legal aid clinic. And that was my first introduction to basically providing service, legal service to persons in need. And it basically catapulted my career. When I left law school, my first job was at the Georgetown Legal Aid Clinic in Guyana. And that service, that nonprofit entity at the time was actually funded by USAID. And we started in Georgetown, and I worked there for several years, assisting women at various levels of representation, whether it's domestic violence, property issues, child support matters, anything matrimonial, divorces, etc. But what I want to highlight is that currently the Georgetown Legal Aid now has expanded to be called the Guyana Legal Aid. And it's not just limited to Georgetown, which is the capital. It's been extended to the other rural areas, Berbice. It's also in Essequibo. And so I can say with confidence that if the country keeps expanding that access to justice, we can see a reduction in domestic violence, because Guyana is one of those countries that have one of the highest incidents of domestic violence. And one of the issues related to that is the access to justice. Women don't feel comfortable making the report to police. They don't feel comfortable that if they make the report, that something will be done. And even if they make the report, they don't feel safe after the report is made. And even with a protection order in hand, they still don't feel safe, because you still have to have ancillary services such as shelters and places that they can go to be safe or to be protected from the abuser. So with the expansion of the Georgian legal aid to the Guyana legal aid, I can confidently say that, yes, with respect to Guyana, there has been some growth in terms of the access to justice for women within not just the urban areas, but within the rural areas as well. And Trinidad also, I've noticed that they're also on that trajectory where there is a national legal clinic that is moving from community to community, providing legal services. Here in New York, I volunteer with Access Justice, which is a nonprofit organization out of Brooklyn that provides legal services to persons of low income. There's a means test. They have to satisfy certain criteria, and then they're assigned an attorney to assist them on whatever their need might be. It might be a matrimonial matter, it might be a wills matter, it might be a bankruptcy. But if they have the need, the service is there in the US to assist them, especially here in New York. So I just wanted to take you through my journey so that you can see from a practical standpoint, we are assisting persons who need access to justice. And
That's been a part of you. That's been a part of your legal journey for a number of years, and congratulations with that.
Yes.
Alicia, based on your experiences, what are some of the accomplishments or programs that civil societies have made in supporting access to justice for Indigenous women in the Pacific?
Thank you again, Laverne. Again, there are many examples that I can speak to in terms of civil society's accomplishments that support Indigenous women in the Pacific in terms of access to justice. But I'm going to, again, in the interest of time, cover certain areas. And so some of these accomplishments that we see are in the provision of what we call innovative services. So for example, approaches like the one-stop shops in Papua New Guinea, in hospitals there that offer multiple support services. We have also seen training for counselors in Fiji that emphasize gender, human rights, and women's autonomy. It has also been found that the informal village-level support networks have been very effective or proven effective. In terms of women's organizations, Fiji's SSVM, which is an Indigenous women's group, they encourage handicraft and income-generating activities, fostering tradition and supporting women's public participation. Again, all of this builds confidence, builds those relationships and trust, including trust relationships, such that if they are in need, they will seek the assistance or will provide assistance to others. In Kiribati, we have Kiribati Amak, which is supported by government and other partners. They advance women's rights and they try to emphasize, again, the prevention and protection of the prevention of harm and the protection of women's rights, even before there are any challenges or difficulties that occur. In terms of youth empowerment initiatives, Samoa's Brown Girl Woke, they focus on inclusivity, diversity, mentorship for young women, supporting academic achievement, self-confidence, and leadership. Economic empowerment, the PNG Women's Chamber of Commerce, they empower women entrepreneurs through capacity building, networking, training, and business coaching. And they also support informal businesses to enter the formal sector. With regards to leadership and mentoring, we have PNG's Senior Women in Leadership Research Group and Samoa's Women in Leadership Advocacy Group. Both of these organizations foster mentoring and gender equality among women leaders. In the Solomon Islands Ramsey Project promotes gender mainstreaming, leadership programs, and media initiatives that showcase female role models. In terms of regional networks, we have the Bougainville Women's Federation that advocates for women's empowerment and inclusion in decision-making. We have Ihagan Familao in Guam and the Pacific Indigenous Women's Network. They build alliances and support networks for Indigenous women, focusing on human rights, cultural preservation, education, and mentoring. And what has also been found to be very effective is in the engaging of men and boys. So programs like the Pacific Male Advocacy Network that advocate and encourage men to become agents for change and in the context of promoting gender equality and nonviolent behaviors. And the Fiji Women's Crisis Center has also developed resources for engaging men in violence prevention. There are also faith-based and media approaches. So initiatives such as the Weavers Program and Churches Partnership Program, they integrate violence prevention into faith-based curricula and outreach. And FemLink Pacific uses media to counter stereotypes, to promote women's leadership, and to facilitate regional feminist networks. I also wanted to share information on the Pacific Islands Forum, again, that I referenced earlier. They are not part of civil society or considered an NGO. They are an intergovernmental organization. However, there's some work there that I believe is beneficial to share. So the Pacific Islands Forum was founded in 1971. It is considered the Pacific region's top political and economic organization. And the member state countries are the independent and self-governing states of the Pacific, along with Australia and New Zealand. There are other Pacific islands, including Guam, for example, that are considered observers in the Pacific Island Forum. All of the Pacific Island countries have made commitments to achieving gender equality via the Beijing Declaration and Platform for Action. Almost all of the Pacific Island countries have ratified CEDAW. All UN member states in the Pacific also adopted the 2030 Agenda for SDGs, which of course includes gender equality and access to justice. And in 2023, the Pacific Island Forum leaders endorsed the revitalized Pacific Leaders Gender Equality Declaration, which renewed their commitment to gender equality and social inclusion, which is in line with the Pacific Leaders 2050 strategy. And what this declaration does is that it also reaffirms that climate change and disasters, including nuclear contamination, have a disproportionate impact on women and girls in all their diversity, particularly women and girls with disabilities and women and girls who live in rural, remote, and maritime areas. The declaration also recognizes the responsibility and the importance of engaging men and women, girls and boys in working towards, again, the Pacific Leaders 2050 strategy. There have also been substantial efforts to improve documentation of violence against women and to increase the comparability of data that is collected across the Pacific region. And in the international and global arena, we have the International Indigenous Women's Forum, or FIMI, who has united Indigenous women's organizations, leaders, regional networks, and activists globally to support Indigenous women's rights and to strengthen Indigenous women's leadership through advocacy, research, and resource allocation. So all of these, again, are examples in which in the Pacific society, civil society has, again, put forward efforts to improve access to justice to Indigenous women in the Pacific at all levels, whether local, domestic, national, regional, and international, or globally. Thank you.
Thank you so much for that response. Alicia, let's talk about Guatemala just a bit. What are some of the programs or accomplishments of civil society in Guatemala to support Indigenous women's access to justice?
Thanks. Well, as I previously mentioned, the work of civil society organizations, particularly women's organizations, has been crucial in transitional justice context. But in this case, however, I would like to highlight a group that remains particularly vulnerable. The majority of domestic workers are women, and many of them are indigenous and are migrants from other parts of the country who come to the city in looking for job opportunities. These workers are exposed not only to violation of their labor rights, which can sometimes constitute labor exploitation, but also to a significant risk of physical and sexual violence in their workplace, because many of them live in their workplace. With the Legal Reform Fund project of the ABA that implemented in Guatemala, it provides us an opportunity to collaborate directly with CSOs representing domestic workers. This initiative supports the ratification process of the Convention 189 of the International Labor Organization by the Guatemalan Congress. Then this should pass as an initiative of law that was introduced in 2015 and has faced challenges due to a lack of interest among legislators. But also, and I think this is important, due to significant issues of discrimination and forced labor to this population. During some of the meetings we had with the project, we heard from representatives who expressed concern that if the ILO convention was approved, it will have a negative impact on women due to potential loss of employment for many of them, as many people will not be willing to pay the minimum wage or offer decent working conditions. These kind of organizations have made significant efforts to raise public awareness and engage decision makers on this issue. However, the country continues to normalize this practice of basically slave labor. Domestic workers organizations like CentraCap, that also was one of our partners in the Human Rights for All project of ABA, are working hard to advocate for their rights and provide support to domestic workers. They offer services such as psychological counseling, adult literacy education, because many of these women are from rural areas and they don't know how to read and write. Training workshops in workers' rights. Although this progress is extremely slow, these women have been fighting for years, and I am sure that they will continue to do. And they serve as an example for other civil society organizations, but for many women and for people that are working for looking for justice like us. So I think that Central Gap is like one of the best examples. And to close this space, I would like to share an important announcement. Yesterday, the president of Guatemala appointed Magdalena Hochola as an adjunct judge for the Constitutional Court. She is a Mayan Kachika lawyer and the former human rights advisor for the ABA's Human Rights for All project implemented in 2024 in Guatemala.
That's a wonderful announcement. Wonderful. Zamira, what are some of the normative developments and achievements that you've seen that facilitate migrant women's access to justice?
So we have seen a number of like overall developments that are globally that are specific to women, to migrant workers or to women, and then like sort of the intersection of the two. Of course, the ILO Convention 97 that is about migration for employment. It's not a new convention. It's from decades ago, and yet it still sort of remains very relevant in terms of the kind of non-discrimination in employment against migrant workers and the ability to access labor rights and including access to justice. The, then there is the Domestic Workers Convention, which is there extends the labor protections to domestic workers and recognizing domestic work as work. They're entitled to those protections. There is Convention 190 that deals with violence and harassment at work, so gender-based violence and sexual harassment at work, sort of recognizing everybody's right to be free from that in the workplace, including migrant women. All of these conventions, in addition to the conventions themselves, then have gradually sort of gradual jurisprudence, or in the form of general comments or observations by relevant committees that have specific observations as it relates to obligations of governments in protecting the rights of migrant women and the access to justice, including, as Alicia mentioned, CEDAW, the Committee on the Convention on All Forms of Discrimination Against Women, has had specific observations opposed to as it relates to Indigenous women, but also to migrant women, specifically Recommendation 26. So we have seen these developments. But what is the problem? The problem is that the receiving countries are reluctant to ratify these conventions, or even when they have ratified, sort of to really implement these specific kind of more extended observations or interpretations and applications of these conventions when it comes to migrant women. So that's why in the wake of that kind of reluctance from the government, which, as Ligia noted, there is this argument always, if we protect their rights, then they're going to lose whatever little thing that they have because nobody will pay them. But, that argument, of course, is not a legitimate argument, because we have seen when the floor is raised, which it should be because we have international standards on those issues, then, there is a way to actually comply with those rules and regulations, and this sort of fear-mongering around the fact that if we raise the standards, then compliance will be impossible. So because of that, these new developments that we see on human rights due diligence that are mostly applicable to big giant corporations, but nonetheless, because they're such primary employers, because it's not just about their own immediate employees, but also down the line in the supply chains, hopefully kind of using these basically domestic regulations where these corporations are headquartered to make these international standards directly applicable to the corporations as opposed to only to governments, should make some positive changes. And that's why I see these normative developments that may not be at the global level necessarily, but in specific, at the EU and some specific national jurisdictions that specifically reference these conventions. Well, not all of them, but some of these conventions. I see them as an important way of implementing these international standards.
Well, thank you so very much. I want to say that I certainly have been informed by this wonderful conversation, and all your comments were designed to raise the bar, raise the level of consciousness, and to generate hope. There's certainly a lot of work to be done, but progress has been made. We do have a few questions. And I will start with the questions from the attendees online. And whomever wants to take a stab at this is fine. The question is, women are the largest users of customary and informal systems. How can we strengthen multi-sectional and multi-generational partnerships to enhance their participation in these systems, and which collaborations have proven effective? Who wants to take that?
Okay.
All right, Velna, go ahead. I hear you trying to talk.
Okay.
No, I was going to defer, but in terms of generational collaboration, I think with the advent of AI in this particular age that we're living in, that platform is probably one of the new tools that the current generation is most au fait with. And the previous generation or persons senior to myself may not be as au fait with those tools as the current and the younger generations are. So in terms of utilizing that tool to integrate the access to justice, I think as young people and as legal professionals here in New York, we should be able to encourage the older generation using different educational tools to utilize this resource and share it not just within our own community, but with other communities as well, so that the knowledge can be utilized and shared and used for the greater good and education of all the generations.
All right, thank you.
Laverne, I can maybe just add.
Mm-hmm.
So what we have found is in the coalition building, right, that we have, and whether they are at the regional, the local, the national levels, and of course, even at the international global levels, there are affirmative, deliberate and intentional efforts made to include youth, right? To include young women in these spaces, and very specific times and meetings and dialogues that are had that focus on youth and young women and girls. And so having those continued conversations and discussions and dialogues and engagement, we have found that those have been effective. And so it's not just a one-time situation. It's an actual formal invitation. It's a formal participation because of the recognition and the acknowledgement that we must include all voices, and as we say, right, women and girls and all their diversity. And so these are efforts that continue to be made and have been found to be effective, right? Is to give that confidence and to give that encouragement to have their voices heard and listened.
Thank you. We have time for two more questions, and the question I received from an attendee online, Alicia mentioned restorative justice traditions being integrated by Indigenous women. Have we seen anything similar in Guatemala or in migrant women's access to justice?
Yeah, well, yes, but it's like not so common. We have and I think like this is one of the saddest things of our justice system. We work in an official system that it's supposed to recognize indigenous organization, and they're our form to impart justice. But I think the case of Sepur Sarco has a lot of documentation on how they approach to these women, because they are like mayor like women. We call her in Guatemala las abuelas de Sepur Sarco, the grandmothers of Sepur Sarco. And so it was very hard for them to speak to speak what happened to them, because it was a case specifically of sexual violence, and they felt guilty, they feel embarrassed of this situation. So, including like the view of the Mayan view, and respect their culture, their beliefs, to apply this for the traditional system. It was like the best example, and I think it's a way to replicate for other cases of transitional justice, but for also for common cases.
Thank you so much. This last question, it's twofold question. Anyone can respond. It would be nice if all the panelists can, take a few minutes to respond to these two questions. And then following your responses, I'll turn it back over to our chair, Paulette, so she can offer some final words. How much do you think the bias of justice sector actors contributes to the experience women have within the justice system? Are there ways to combat the bias and attitudes that persist even if other protections are in place?
I can start. Certainly, I mean, not to sort of generalize, but the comment I was making earlier in the beginning about sort of lack of participation of specific communities both in the design of the justice systems, as well as what Alicia was saying in terms of lack of these women being, or women at large being represented as, for example, as judges or leaders. All of that then impacts sort of how, whether that's conscious or unconscious bias that justice actors have towards specific communities. And in today's world, we see there's so much rhetoric, right, about immigrants or migrants that is certainly going to have an impact one way or another on how people perceive certain populations, not just as sort of, they're not seen necessarily as legitimate rights holders. And so when they're not seen as legitimate rights holders, then sort of their ability to assert those rights, of course, is going to be impacted, including by the way they're seen by the various justice actors, including, not just the sort of prosecution, defense, or judges, but even people like police and law enforcement. So what was there a twofold? Was there a second part of that question in terms of things that have worked or
Yes.
something like that?
It was, are there ways to combat the bias and attitudes that persist even if other protections are in place?
And I think that sort of one of the sort of more, one of the ways that, again, I'm going to keep stealing from you, is, of course, sort of diversification of the bench, right? And not just of the judges, but justice actors at large. So then you go back to sort of access to education, access to ability to become lawyers, where if the justice actors are more reflective of the population they're serving, then there will be more opportunities to sort of to counter those biases, or to at least kind of have some pushback against them. In any change, the behavioral change happens through personal experiences more, and this is sort of scientifically more so than if you actually take a paper and learn about all the forms of discrimination, as opposed to what experiences have that formed your belief systems. So providing opportunities for people to have more diverse encounters then also impacts their biases.
Thank you.
I would add to Zamir's comments. So we talked quite a bit about raising awareness, and whether raising awareness is in the context, right, of formal training, right, and formal training with regards to all actors, right, because there are various sectors of the community, of any community, where it may be, predominantly male, for example, right? And so training, outreaches, anything that would again involve raising the consciousness of individuals to understand the importance of, increasing in the inclusiveness of women voices, the voices of young women, of girls. All of those are positive efforts. In some parts of the Pacific, there have been also, I believe, legislations that have required that the makeup of certain forums, whether it's a legislative forum, whether it's a commission, whether it's a board, but that a certain percentage of those that become representatives are comprised of women, right? So there are those efforts that have been made, and in some parts have been found to be effective and positive. And then in terms of the judicial system, there is variation in the Pacific. In some islands, we have a predominantly female bench, meaning most of the judges are actually women. I believe that's the case that we have in Guam. And in other island nations, it may not be that way. But what happens is that this is, again, an evolving process. It comes with education, it comes with persistence, it comes with the political will, right? So we talk about the political will of those in authority who are, again, we're with advocates, right? With others who engage, again, all sectors of our community, so that we raise that level of awareness to include more women voices, more the voices of girls. And so we also went back to the Engaging Men and Boys, right? Those programs, they can, again, it's engaging boys at very young, right? Very young ages, engaging men. All of these can have a positive impact in terms of promoting gender equality, inclusive of our judicial and legal systems. Thank you.
Okay. So I think we all come to whatever service we provide with certain intrinsic biases. And those biases may be based on our personal experiences, our culture, our background, whatever experience we may have, whether it's at work or at home. And how do we overcome this bias when we're dealing with migrant women in terms of their access to justice? From a judicial perspective, I know in Brooklyn, there's a proliferation of female judges from the Caribbean because there was an active goal to have women that look like us on the bench, so that when we go before them and when our clients go before them, they can feel heard and understood and appreciated. So I think one of the primary ways of combating the judicial bias is to get people that look like us on the bench. In addition to that, whatever your cultural background is, you want to have somebody there as a representative. And in the event we're not able to do that, you want to be able to expose those judicial actors to those cultural experiences so that they can garner an understanding of some of the history and reasons why, a particular culture or religion or race will conduct themselves in a certain way. And that can only be done through exposure and education. So I do believe that the biases can be addressed and they can be combated, but it will take time. And of course, it will take a deliberate effort. If you're not aware that you have the bias, that's a whole other problem. But if you're aware of it, or if you've been made to become aware of it, then definitely you want to take some active steps to ensure that those biases are addressed and eliminated, especially when it comes to access to justice for women throughout the region.
Thank you for your responses. And Alicia, did you?
Yeah.
Okay, go ahead.
Thank you. Well, I consider that bias can be reduced through actions such as education to justice workers, but this is insufficient without the social change. The Inter-American system condemned the state of Guatemala for 3 cases that lead to the creation of a specialized justice system for women in criminal cases. And it has been a long process of strengthening for several years. But with the deterioration of the current justice system by the anti-democratic actors that had taken our justice system, these efforts that had been implemented had been lost. However, I think CSOs has also have been vital in raising awareness among the population. But I want to point that how fragile is our system or our advances that we made in these years, that with a democratic crisis like we have in Guatemala, we had lost a lot of these efforts that we made in the judicial system.
All right. Again, thank you all for your remarks. And at this time, I'll turn it back over to Paulette, our chair.
Great, thank you. Thank you so much, Laverne, and thank you to our outstanding panelists. Like Laverne mentioned, I learned a great deal. I think this is such an important issue, and I think about some of the places where I've traveled, where immigrant women, Indigenous women have had such troubles, navigating the system, and how they are constantly discriminated against. I think about, Dalits, for example, who in some places are considered to be non-people, just they don't even exist, so there are no laws for them. But all of this information is very important to impart, especially recognizing the theme of this year's program. And hopefully some of the thoughts and ideas can be used to develop some policies around these areas with the UN. So I am hopeful for that. I thank you all. I thank you everyone who has joined the program today virtually, participants who have joined virtually from Guatemala, and those who have traveled to come here today. And so I thank you very much, and hopefully we will get at some point the video from the president, and it can be added to the presentation that will be available online. I also want to thank our 2 wonderful team members who are in the background, Randy Hansen and Elizabeth Smith, for all of their work that they've done to make sure this program was a success. So thank you all. Have a wonderful evening and a wonderful rest of the conference. Thank you.